Good afternoon again. Please call the next case.
Robertson, Anschutz, Schneid, Crane and Partners, PLLC versus Daniel S. Greenberg et al.
All right, thank you. Counsel, we're ready to hear from all sides. I'm looking for the appellant, and no one is at appellant's counsel's table. Is Mr. Daniel Greenberg present? Hearing no one to answer, is anyone here representing Mr. Greenberg present? Hearing no one answer to that question either. Yesterday or the day before, I've been in court for 2 days, so my timing may be off. Mr. Greenberg filed a motion to conduct the hearing via Zoom or to continue the hearing. The court denied that motion and in the order clearly stated that this case would be heard by oral argument, and here we are. So there being no one, Mr. Greenberg not being here and no one to speak on his behalf, we will now hear from the appellees. The clerk has informed me that each of you has agreed to 3 minutes. Is that correct?
Yes, Your Honor.
Very good. Then she will program the clock accordingly, and the floor is yours.
John Maher from Montgomery County Bar, Your Honor. I represent the appellees Carla Gifford, Madeline Greenberg, myself, and Nicholas Bellamy. Just real quickly, the court, so that it knows where this comes from. This is a interpleader action for some money that was paid into the court from this foreclosure of a piece of property. And Mr. Greenberg was one of the possible recipients of that, was served. And he, at some point in this pleading, brought a separate lawsuit, interpleader action, against 49 other defendants. The judge ruled under Rule 12B that should be dismissed for failure to state a claim upon whether she may be granted based
Counsel,
on.
I have a little concern with that we may not have a final judgment in this case, and therefore Rule 3 appeal wasn't appropriate. Your clients had a motion for sanctions at one point, did they not?
Yes.
I don't see what happened to that motion in the record. So do we have an unresolved motion that prevents us from having a final judgment here?
No, I think the judge put down an order saying that all other motions are disposed of and denied.
Okay.
And she did orally in court deny our motion for.
So is that language in an order that you can point me to in the record that has all motions not previously dealt with or hereby denied?
I can't point to you directly at this moment, Your Honor,
Okay.
because it's so voluminous.
Well, I'll just warn the other appellees. I'm going to ask if you've got another motion that I can't determine how it was, I want to make sure we've got finality here.
Okay.
Yeah.
And I think there were some motions that different plaintiffs had filed or different defendants had filed for the court to put down a final order too, and I think she had done that as well. Okay. So, but essentially, Your Honor, the 12B motion is based simply on the fact that all of his claims are based on this order from California that he says it cannot be enforced because of this guardian ad litem was pointed to. That case was litigated and decided, and the court domesticated that foreign order before this action. So it's just all null and void. Everything stems from that. So he has in light most favorable, he has nothing to stand on with regard to that. He did not, and I think we could not even really determine what he was appealing because there were his statement of issues was so nonsensical. We could only.
Well, and I guess that's another question I've got in a case like this. I mean, I've looked over Mr. Greenberg's brief, of course, and then he did a filing this afternoon or this morning with, it looks like, a substitute for oral argument. If we agree with the position that he has not engaged for the rationale why you or your clients were dismissed, is the proper disposition here an affirmance, or rather is it the appeals dismissed?
I think you affirm the trial court's decision.
Okay, not dismissed his appeal.
Right.
Okay.
And
why is that?
Well, it depends. I guess it could be two-phase, Your Honor. One, if you find that he didn't, if his appeal was so defective that it just dismissed it, that would be phase one. And if the court
Because
decides
that's
that,
normally, if, analogizing to this situation, and you're basically arguing that the brief is deficient under Rule 27.
correct.
Ordinarily our disposition would be not affirming the trial court, but your appeal's dismissed because you didn't really give us anything to look at here.
Right, and so that's why I think we kind of bifurcated our answer, that if the court found it is sufficient under the rules to go forward, then we'd like you to affirm it based on the factual basis. And we do think he did waive the motion for summary judgment that we succeeded on, because he did not argue that on appeal at all. And so we think that that's waived. Yeah. And we'd like the court to put down in its order that it is waived because he hasn't raised it. And so that would be all from my client's position, Your Honor.
Very good. Thank you, sir. Good afternoon.
Good afternoon, Your Honors. Cassandra Crane on behalf of who I've called the California Judicial Defendants, and that's composed of a justice from the 4th Appellate District Court in California, 6 trial court judges, and the Superior Court of California for Orange County. And Your Honors, the judicial defendants were named in the underlying trial court action. However, as set forth in our brief, these defendants or appellees were never noticed with the appeal, and they're not mentioned in the brief except for one judge, Judge Palafox. So I would argue, Your Honor, that this appeal should be dismissed against these defendants. The reason for the dismissal of the California judicial defendants was that there was no personal jurisdiction over these defendants, and Mr. Greenberg failed to raise that issue at all in his appellee brief. So unless the court has further questions, we have nothing else.
Any further questions? Hearing none, thank you, Ms. Crane.
May it please the court, my name is Timothy Palmer. I represent Dean Chris Guthrie of the Vanderbilt Law School and Dean Alberto Gonzalez of the Belmont College of Law. Much like the other appellants that have made argument thus far, this appeal is due to be dismissed. Neither Dean Guthrie nor Dean Gonzalez received appropriate notice in the notice of appeal or listed in the notice of appeal. They are not mentioned in Mr. Greenberg's brief. There is no argument advanced that would meet the dictates of Appellate Rule 27, set forth his contentions against my clients, or why there would be any appellate relief due to him regarding such contentions. And frankly, Your Honor, I tell you, we're at the end of 2 years of litigation, and I stand before you mystified as to what my clients ever did to this man or what they ever did wrong. Judge Jackson's order is clear. There is no factual allegation in the complaint whatsoever that Dean Guthrie or Dean Gonzalez committed any act that could any way be construed as violative or creating a cause of action here. They are simply named.
It looks like your clients also had a motion for sanctions. How was that motion resolved?
Your Honor, my recollection is that Judge Jackson did lay down a
blanket order.
Yes,
and
sir.
Can you point me to that order?
Your Honor, I do not have the order in front of me. It's a great question. But my recollection was that she had the motion to dismiss that then also addressed in a separate order all the motions for sanctions that were pending.
Okay, all right.
And with that said, Your Honor, Your Honors, I have nothing further to add beyond what's in our brief.
All right. Thank you, Mr. Palmer.
Yes, sir.
Hello, Joe A. Helen on behalf of the state defendants here. That would be Judge Robinson, Judge Woodruff, former Attorney General Herbert Slattery, AAG Amber Barker, the Tennessee Board of Professional Responsibility, and the Tennessee Judicial Ethics Committee. The trial court correctly found that there were no specific allegations against my client, and so that the plaintiff had failed to state a claim upon which relief could be granted. The trial court also found that even besides that, The judges had judicial immunity, and Attorney General Slattery and Barker would have quasi-judicial immunity. With regard to the two state boards, that they would have sovereign immunity also. The state would otherwise rely on the arguments in its brief.
Are you proposing dismissal of the appeal or affirmance?
Affirming the dismissal.
Okay.
Thank you.
Thank you. My math tells me I thought there would be a fifth lawyer, but there we go.
Hello, Your Honors. I'm Meg Hancock on behalf of Judge Binkley, appearing for Jonathan Cole with Baker Donaldson. And much like my fellow appellees in this case, there were no factual allegations against Judge Binkley at any point. The appellant never appeared in his courtroom. Judge Binkley never issued any orders in the underlying divorce proceedings or interpleader action. Even if there were any factual allegations, Judge Binkley would be subject to judicial immunity, and therefore we'd ask that Judge Jackson's dismissal is affirmed.
Yeah, Judge Binkley, he has a request for attorney's fees on the motion for failure to state a claim for relief. I mean, and I appreciate that only gets resolved after all appeals have concluded. But I was curious, under the statute, you're not entitled to attorney's fees if you're sued in your official capacity. And since there doesn't appear to be any allegations against Judge Binkley, how do I tell whether or not the fact that he was named was official capacity or not?
Good question, Your Honor.
Or is that for the trial judge to sort out later?
I think that the idea behind that is that we're covering our bases depending on,
I see.
because there were so little factual allegations against Judge Binkley, and we weren't sure if it was in a judicial capacity or in an individual capacity, we'd maintain, even if there were any allegations, it'd be in a judicial capacity. But I understand that's the statute, and we would.
Well, and I guess the other component here is because this was a pro se litigant, normally they're not liable for attorney's fees unless the court makes a finding that the pro se party acted unreasonably in bringing or refusing to voluntarily withdraw the dismissed claim. So I guess that is still to be dealt with, you're saying?
Yes, Your Honor.
Okay.
Thank you.
All right, thank you. I think that's all of the appellees who wish to present oral argument. All right, thank you all. We have heard your oral arguments and have read your briefs. We have also read Mr. Greenberg's brief, and we will take this matter under advisement and render a decision based upon Mr. Greenberg's brief and your briefs and oral argument. That concludes the docket.